Hi everyone, my name's Lewison and I'm a barrister specialising in private client and insolvency. I'm back on the roof of Radcliffe Chambers with another case, and this time it's Missouri Steamship Company, a case about marine insurance of all things. You may be wondering why, but this time it's not so much for the case itself as a challenge it lays down. Lord Halsbury deprecated what he saw as a growing practice of citing American authorities as though they were English ones. He's recorded as saying during the arguments that it involved an inquiry, often not an easy one, into whether the law of America is the same as our own. Lord Justice Fry piled in and described the citation of American authorities as a waste of time. So I thought I'd take up Lord Halsbury's challenge and see if I could find some cases where not only is US law the same, but where the Americans got there first. First up, it's Banks and Goodfellow. Despite some recent efforts in the Chancery Division, Banks and Goodfellow remains the law on testamentary capacity. But unless you've looked at the judgment recently, you may not have remembered that the actual formulation of the test was taken from a trio of American cases: Harrison and Rowan, Den and Van Cleve, and Stevenson Van Cleve, all from New Jersey. So not only is the law the same, but actually it was adopted from American law wholesale. Now, you may think that Banks and Goodfellow is a bit of a swizz because it was decided 15 years before Lord Halsbury's statement in Missouri Steamship. So how about this? Husband and wife are making mirror wills, but when it comes to executing them, the husband signs the wife's will and the wife signs the husband's will. Nobody notices the error until one of them dies. What, if anything, can the court do to help? This is Marley and Rawlings, right? In England, the High Court and the Court of Appeal considered themselves powerless to assist. It was not until the appeal to the Supreme Court that it was held that the statutory power of rectification was available so that the deceased testator's will could be given its intended effect. That was in 2014. Over 30 years earlier, the Court of Appeals of New York, which is their apex court, had held that on similar facts the court could admit the defective will to probate. The justices held that the husband and wife's wills could be read together, there was absolutely no risk of fraud, and the refusal to admit the will would expand formalism with no corresponding benefit. That case, in the matter of Snide, was actually cited to the Court of Appeal and the Supreme Court in England. The English Court of Appeal refused to follow it, largely because there was a body of cases from around the world all pointing in different directions, and because one judge in Snide had given a powerful dissent. The Supreme Court didn't mention it at all. But our third area, to cap it off, is one that I think is a really close match. A lawyer drafts a will for a client, but makes a mistake so that the will doesn't give effect to the testator's wishes, and some of the intended beneficiaries don't get the gifts that they were supposed to. Do the disappointed beneficiaries have a cause of action in negligence against the lawyer? Well, we all know the answer to this. It's Weiss and Jones, a decision of the House of Lords in 1995. Or is it Lucas and Ham, a decision of the Supreme Court of California in 1961? Mr. Ham was an attorney who attempted to draft a will for his client, Mr. Emick. The gift of residue was left on the terms of a trust that was to terminate 5 years after the grant of probate. At the time, California had the old rule against perpetuities, meaning that the gift of residue failed because probate could in theory never be granted or could be granted less than 5 years before the end of the perpetuity period. The court held unanimously that the disappointed beneficiaries had causes of action in tort so that they could sue Mr. Ham. But brilliantly, the court held that Mr. Ham was not in breach of his duties. The rule against perpetuities was so difficult to understand that it could not be said that he'd failed to act with ordinary skill, prudence and diligence. But does any of this matter? Was Lord Justice Fry right to say that looking at US cases is a waste of time? I suggest not, particularly in areas of developing law. While the English courts are willing to look to many Commonwealth jurisdictions, America has much to offer. As an example, no contest clauses in wills are becoming much more talked about here in England and may find their way into litigation in the next few years. There's not much English law on them, but in California they've been codified by statute and there's a decent body of cases to look at. So I suggest that if you are looking at a field where there isn't much authority or much modern authority, it is well worth looking west. Now, it's thanks to Jess Henson at Payne Hicks Beach, Alison Regan at Russell Cook, and Josh Ryan at Waitmans who tell me they watch these videos. And if you've enjoyed it, then give it a like, give it a share, or get in touch. And until next time, thank you for watching.